a statutory Buganda Land Board in place. I would like to pick your views on that, Ochitiwa Katikiro. Number two, we had eminent people here who came and talked to us. And one of them, Ochitiwa Peter Murira, I think he came here and emphasized the fact that it was not proper for us as a nation not to maintain the sovereign title in the state, eminent domain, that it wasn't wise and it wasn't proper, because I think according to him, I may not so much really re-echo his words, lest I spoil them, but I think in essence he was saying, look, land is for us. It's a gift from God. It is for the dead. It is for those who are living. It is for the unborn. It is land. We didn't create it. We found it here. Purposely for the people. Under the land, people have got their rights. Rights of man. They are always popularly known, rights of man, including, of course, woman. Who is the guarantor of the rights, of our rights? The guarantor of our rights is the state. You can say they are inalienable, coming from God, but the guarantor is the state. So something must flow through a sequence of events from God, then the state as the embodiment of our rights, the protector of our rights. Then from there you get your rights. I think that's the basic thinking and principle. Not that, of course, you know, the challenge is always the perception that the speaker was talking about, always wanting to ride on cheap popularity. That when there is a sovereign title, then the state is there to take your property. That kind of thing. But that were his views. And Ochitiwa Katikiro, I would like to hear your own views on that kind of thinking and what you still think, what you think about sovereign title. Do we maintain the status quo as it is in the Constitution? Do you think it needs a bit of revisiting? We want to hear your views on these very hard questions. And I think, but by the way, when we get the write-up from Ochitiwa Apollo Makubia, Ochitiwa, you wrote a good book, very valuable book, King on the Throne. And thank you so much. I had an opportunity to read it. And then again, perception. For instance, when you talk about federal, if you were to be frank with me, the federal you are talking about here may not even be the federal the people of Uganda think they want. Perception. There is the popular federal. The popular federal. Federo. The Jordan way of that existence of Buganda as it then was, absolute monarchy. And that, they could be calling that one the federal they want. There is the federal we know in the modern way of understanding how institutions function, how powers are developed, how powers are shared, and that kind of thing. So maybe, if not now, maybe in your write-up, which I know you have got a lot of good wealth, you can give us some of your views to understand and to capture your actual mind. I think finally, my lord, I think on regulated land use. Me, by the way, I agree with that thinking. And regulated land use, regardless of whatever you call, we seem to be quarreling more on form and not on substance. This is why you hear these views, contradictions, Milo, freehold. Shareholder, Shakespeare put it very well. Actually, he said, after all, what is in a name? A rose, by whatever name called, smells as sweet. Whether you call it substance. Now, when you come to substance, for instance, you try to distinguish freehold from Milo. You said freehold, commonly understood, would come with conditions. Do this, build a church. Do this, do that. And that free Milo didn't have those conditions. But in contrast, your proposal is whether you have Milo, or whether you have freehold, whether you have whatever system of land tenure, government can have effective laws and policies in place to regulate land use. In other words, you cannot, for instance, put Milo next to Sheraton here and you leave it vacant, or you go there and construct a mud and water building. Then government should come in and say, no, you cannot put this. There are even sanctions for doing that. So you see, we are coming back to the same thing. So even if you are, even when you try to to distinguish Milo and freehold, you still also hit yourself in the foot by saying, no, you can even regulate Milo. And me, I would be more interested, names notwithstanding, Milo, freehold, customary freehold, I would want to hear much more of your views on how we can effectively use land. You know the debates, there were debates, tax unutilized land. That one got defeated. You can even say, give so much land in freehold. Above that, it must be leasehold. Many ideas can come up. How effectively can you use land properly and encourage production, encourage investment in our country, and develop our nation? Finally, in the promised work or write-up that you want to give us, I'll give you an example. I would expect, don't say, let's have special courts. Fine, it's granted. Now, but how effectively should these special courts function? How effectively? Let me give you an example. District land tribunals collapsed. There are many challenges. One of them, many of you, including you, OHT, you are a practicing advocate. Quorum. was a problem. Hardly would you ever find a panel of 3 sitting. If one was there, another one was absent. How effectively, what processes, what procedures should be put, what type of simplified mechanism should we put in place for these institutions to function? Simple but effective. Simple but effective. You know, this commission, I don't want to blow our own trumpet, but you know, the extent of our success is because we command most of the processes. Investigation, we have our own investigation machinery. So it's not a tribunal seated and then listening to 2 battling lawyers on points of preliminary objection, spending a whole year on one issue, preliminary objection. You know? You find a whole tribunal court spending a whole year without listening to the aggrieved party. It can't be the case in this commission. We are straight with the person who is actually complaining. So, also bring to our attention those mechanisms that can bring about effectiveness in these proposals that you make. I thank you, my Lord.
Thank you, my Lord. I think the Honorable Ruhindi wants to know why we pulled out of the regional tier, regional government arrangement. There were 5 challenges, and they are not confidential because we talk about them every day. The first one was the election of the Katikiro. There were grave concerns that if the Katikiro of Buganda was elected through universal adult suffrage, somebody who is completely oblivious to the certain significant aspects of Buganda's heritage could be elected Katikiro. Now, Katikiro is not merely administrative. There are cultural functions the Katikiro plays. For example, I'm responsible for the prince there. It's my job because his father was a Kabaka. It's my job to actually, in the strict sense, to determine how he lives his life. When it comes to issues of succession in Buganda, the Katikiro has a very big and significant role. When it comes to the way the Kabaka governs his kingdom, the Katikiro has a lot more role than what you see me doing here. The Katikiro is like the link between the clan heads and the Kabaka, between the royals and the Kabaka, and the ordinary people, and so many other things. So, an election in the name of democracy could destabilize the kingdom. So that was a big challenge. We failed to, I think, agree on how it could be done. 2, the second challenge.
So how different would that be under the federal arrangement that you are proposing?
Well, that has to be worked out, because under the federal arrangement there must be an element of democracy for sure. But how that is done is a detail that I can't go into here. We could stay here the whole week, things you don't like in this commission. But that is a detail that needs to be worked out to cater for the 2 situations. How do you maintain the cultural integrity of the office of Katikiro vis-a-vis the democratic requirements that a federal arrangement espouses? You have to find a balance between the 2. It has to be worked out. If you don't work it out, the people are apprehensive and they're afraid to go into it. The second challenge had to do with the finances to run the regional administration. We wanted constitutional guarantees that the functions that are left at the region are constitutionally funded, not at the benevolence of somebody. We don't want a situation where the president is not happy with us for whatever reason. He withholds the flow of cash. How does the regional government run? That wasn't done. The third challenge was about the districts. Because the districts under the regional arrangement would report to Kampala. And they would report at the regional headquarters as a matter of courtesy. Now, if I am the regional head and the people I govern don't come to me, they go to someone else, then I'm not in charge of them. It's a mockery of the purpose for which the regional government was set up. The fourth was land issues, actually. Because under the regional arrangement, public land within Buganda wasn't placed in the hands of the regional administration. The central government insisted that land should be governed by districts, wherever they are. Now we have about 80 districts in Buganda. Tomorrow there could be 100. It creates so much confusion. We were of the view that public land in Buganda should be managed by the Kabaka through agencies he puts up, like the Buganda Land Board. And the fifth was the president's prerogative to take over a district where he felt that that district's subculture was being subdued. Now we thought that was dangerous, because who defines when a subculture is being subdued? Who defines the subculture in the first place? So for those 5 reasons, we felt it was not safe for us to go in the arrangement. And we've expressed these views to everyone in the country. Now, the kind of federal people want about an absolute monarch, I think Buganda has moved from that. Even at the time of independence, the condition was that you either grant us a federal system or we go it alone. Because the federal system would grant us the space to handle some internal issues which don't affect the national interest. And the concession was that we go for a federal arrangement where Buganda, for instance, would handle certain internal issues. I think the kingdom has moved away from that. I understand there are many people who want an absolute monarch. That is not going to go away through legislation. People have got their feelings. And it arises, by the way, from the way people view the central government. If the central government isn't seen as being responsive to people's needs, people then ask themselves, why don't we go it alone? But I think we've moved from that. The general view is the federal system, which essentially means sharing of power and defining what the central government deals with and what the regional government deals with. And that arrangement should be available to everyone who thinks that it would help. I, for one, think it would help everyone in Uganda if we had that arrangement. The debate by Senior Counsel Peter Mulira, I think the status quo is okay. Land is vested in the people of Uganda. And for me, eminent title, the state, in any case, when you talk about the state in a neo-colonial situation like Uganda is in, the debate can go on and on. Is the African independent state actually capable of effectively sustaining the rights of the people the way we understand it? In the sense that Ojitiwa Mulira is defining it. I think land vesting in the people of Uganda is okay with me. The only problem is how effective the laws behind this are to ensure that everyone enjoys their proprietary rights. The Honorable Hind talked at length about regulated land use. My Lord, the laws are in place, even as we talk now. For example, the Country and Planning Act stipulates the processes we must go through as we carry out developments anywhere in the country, but they are not being implemented. The laws that set up urban areas, town councils, just because you have a mile title in Rubaga doesn't mean that you should put up any kind of house you want. Actually, the urban authority has the mandate to tell you where your house should face when you examine the law properly. Even the colors you paint your house can be determined by the urban authority. The color where the house should face, even perimeter walls. Actually, there are bylaws by KCC. You're not supposed to build these 6-foot perimeter walls we put around our houses. It's against the law. But the first thing you see when you visit residential areas are the ugly barren walls all over the place. One uses half bricks, another uses slates, another uses a pink color, another uses purple. Some urban areas look like kindergartens. But the law is there, but it is not being implemented. So what is required, in my view, my Lord, is that the institutions that are supposed to enforce the law do enforce the law. Where I stay, people are building perimeter walls up to the road itself. And I told them, you're supposed under the law to leave 3 feet for utilities, water, and all these things, drainage. And they said, this is my land, I've got my title. But that's not what the law is. So, for me, whether I have a Milo title or my neighbor has a freehold title shouldn't be the issue at all. That's why I don't see the need to cure something which isn't sick. In our view, the Commission should help us cure the illness. The illness is not in the land tenure system. That's why I don't want to tamper with it and cause undue apprehension. The illness is within the institutions that don't carry out their mandate. Governance issues, I must re-emphasize. Because if the urban authority ensures that no structure is put up without an approved plan, and an approved plan shouldn't be a matter of a stamp, because that also happens. Many people have approved plans when the authorities haven't even gone to look at the structure under construction. They look at a computer-generated plan and they think it is good and they stamp upon it. And as you are living in peace in your little house, somebody puts up a skyscraper over your head. And of course, what comes from this is usually confusion and slum condition. The Honorable Commissioner wanted to know about our view on how effective the special courts should be for them to function. Well, I think it would depend on the law that sets them up. First, the mandate that the law that sets up the special court with regard to government projects, the law that sets the court must define the mandate of the court. To the practice guidelines should be very crucial in the way the court goes about its work. Because it could be, I can give the example of the commercial court. When the commercial court was set up, every lawyer thought that commercial disputes would be disposed of within 2 weeks, 3 weeks. When I started practice, disputes were disposed of in a month's time. And that's not very long ago. So the commercial division was set up, but it became like any other court. Preliminary objections taking months to be disposed of, and the judges not being around, and the lawyers coming up with all sorts of excuses to seek adjournments and all these things. So I think that the law itself that would set up the special courts and the practice guidelines would determine whether the special courts are of any value. Otherwise, they could turn out to be like the ordinary land division of the High Court, where the judges simply cannot dispose of the cases because there are too many. And it is the same old system we've had for years and years, yet the disputes are so much more.
Can I suggest that I ask the next commissioner to ask a question, because she's not going to be here for a very long time, and then we can come back.
I seek your indulgence, my lord. My colleague here wanted to add something brief.
Yes. You want to be brief?
Thank you very much, my lord. Commissioner Ruhindi, in talking about the distinction between freehold and Milo-land tenure, said that actually there is no difference, and asked the question, what is in a name? A rose is a rose and smells the same. But I like to show that some roses have thorns, very bad thorns,
and others don't.
And others don't. Some smell sweet, some don't. Some are blue, and some are red. But when you look at the law, my lord, particularly the Land Act, you will see that the definitions of the Milo land tenure are clearly different from that of freehold land tenure. Section 3 of the Act provides that freehold land tenure refers to holding of registered land in perpetuity and subject to statutory and common law qualifications. I don't want to get into the common law, but under statutory limitations. But if you look at Section 3 itself, and I will, with your permission, my lord, read it for the benefit of the Commission. Section 3 defines freehold land tenure as a tenure, as a form of tenure deriving its legality from the Constitution, and involves the holding of registered land in perpetuity or for a period less than perpetuity. So it's not always the case that you will hold freehold land in perpetuity, on top of the other statutory and common law limitations or conditionalities. And common law, my lord, as you know, is English law. Many times we are required to follow that common law, even though it derives from a different place. But for Milo land tenure, you know, Milo land tenure is a form of tenure deriving its legality from the Constitution and involves the holding of registered land in perpetuity. There is no qualification, no conditions, no statutory limitation, and no limitation as to whether or not it can be held in perpetuity. So that explains our, one can say maybe those can be changed, but that really explains our fear that if you merge freehold land tenure with Milo land tenure and fuse it, you'll be confusing things which are not related, mixing apples with pears, and which will cause further confusion.
Yes,
I think we will move to the next question.
Yes, we'll move to the next commissioner. And I would like to invite Commissioner Mary Chan to interact with the panel. Thank you.
Thank you, my lord. I have basically one question, because the second has been addressed. And that is to do with Chapamgal. I think, as Honorable Wechtiba, you mentioned, that perception is very important. We have been interacting with people, and it seems there is a perception among some people, notwithstanding the fact that you have been going around and sensitizing people on the importance of having this lease to assure their ownership of the land. But there still seems to be some perception or some misunderstanding where people believe that
Galazi. How to pay for RogueSpot with mobile money. When it's a RogueSpot, search and connect to RogueSpot Wi-Fi network. Open your web browser and type roguespot.roguetelecom.co.ug. Once on the RogueSpot login page, select mobile money and then pick your desired package. Type in your mobile number and click on submit. After this, you will be prompted on your handset to enter your mobile money PIN. Enter 1 to approve the transaction. Once your payment is accepted, you will have to wait 30 seconds before you can start browsing, during which you can take this time to review our latest promotions and offers. Blast away on the internet.
Rogue Telco.
challenges with forests, with lakes, lake shores, rivers. How is the kingdom managing that? And what kind of recommendations can you give us to ensure that we protect these natural resources, which for the generation to come, because we are dependent on that? So what kind of recommendations would you give us to do that? Thank you.
And just so that we don't have to ask the question again, there is a sticking issue around the renewal of the lease for the Uganda Girl Guides Association. I think you can see their presence in the room, and it comes from the decision by the Buganda Land Board, I suspect, not to renew a lease that was 49 years given by Kabaka Mutesa.
Kabaka Daudi Chwa.
No, it was, I think, a 1947 lease that ended in 1996. And now the Girl Guides Association has been thrown off the land, and the land has been quietly subdivided and given away to different people, without the Girl Guides Association being given a right to buy, even when they had opportunity and ability to buy. So in terms of how the lease will work, we have an example of the Girl Guides Association. And also in terms of usage, that is a camping site, known forever as a camping site. Now it's plotted and people are building at night. I don't know again how that works. Thank you.
First of all, Chapa Mungalo does not preclude the constitutional and legal rights of a customary tenant, because the customary tenant is protected under the Constitution and the law. So, who doesn't want to get Chapa Mungalo can stay as a customary tenant? That is one. It's optional. It's not mandatory. It's not by force. We only talk about the advantages of a certificate of title to the people. He who wishes to remain as a customary tenant is free to remain as such. Secondly, when the lease expires and, for example, there is no renewal for whatever reason, then you become a Chibanja owner. Again, if after 49 years you are not, if after 49 years for whatever reason the lease were not to be renewed, you'd convert to a Chibanja owner, and you'd be protected by the law. But we encourage people to have certificates of title for the reasons I gave, for reasons which everybody talks about, the advantage of having titled land. But also it's important that there is no institution, be it a church or a kingdom, that can give out an outright either freehold or lease title, because an institution lives in perpetuity. The kingdom isn't going to live only during our time or our grandchildren's time. We must have an arrangement which ensures that this institution has land. And in Buganda, because of the clan system, land is exceptionally important. I'm of the Mutima clan. We come from Bale. Bale is along the Lake Victoria. It's a geographical place. So there should be no situation where that place, for example, if the Mutima clan were to issue a Milo title to someone, and that person sells it to a Pantagonian who doesn't understand this thing. The Mutima clan should always have that land for the reasons of heritage. So that's why even the churches give out leases. Church of Uganda, Catholic Church, they don't give out a freehold title because the church lives in perpetuity. But having said that, the only situation where renewal may not be done is because you haven't complied with the terms. That applies to government as well. When the ULC issues a lease to someone, they'll give you conditions you must fulfill. If you don't fulfill them, then it doesn't get renewed. People always ask me when I go in the countryside, what will happen to their children when the lease expires? Then I ask them, what do you want your children to do? You are 50 years of age. You've got a 49-year lease. It will expire when you are 99, assuming God has been that kind to you. And your child, who is 5 years today, will be 54 years. And you are asking me what your child will do. What will your child be doing? Why can't your child go and fight for his own rights? Especially for the things you worked for. But I know about perception. And the people who fueled the perception are the people who are running to us to give them titles. The very people who are challenging us on the project are the people who came first for titles. So, one, Chapa Mungalo is voluntary. If you don't want to come for a certificate of title, stay the way you are. Nobody is going to touch you. Two, when you get it, we think you're in a better position to utilize your land. And 49 years really with an automatic renewal clause. I don't know how long people expect to live. Because if you've got 98 years on a certificate of title, and your great-great-grandchildren cannot stand up and fight for what you worked for, I don't think that would be the kingdom's problem. And also, customary land is what you convert to. Should there be no renewal? So there should be no worries. The Girl Guides, I think, the Buganda Land Board is here. They can explain. But what I can say, when the lease was given, when the lease was issued, the 49 years expired without, I think, them doing what they were supposed to do on the land. And I think they were given a portion of land where they carry out the jamboree that your lordship talked about. And then they were advised if they wanted more land, they could go to Masakand. We could give them land in Ichagwe, but they insist they want here. But the details can be given by Buganda Land Board that are here. Then about natural resources, my colleague is going to chip in here.
Thank you very much, my Lord Chairman, Chairperson, sorry. With regards, the question was regarding how the kingdom manages natural resources. At the moment, the kingdom does not have a legal mandate to manage natural resources. And one of the issues in the discussions around a federal system of government does include the right of the kingdom, as we perceive it, to manage or to have a clear say in the management of natural resources. Natural resources are a fundamental aspect of the kingdom's existence. The symbols of the existence of, or our linkage between our ancestors, ourselves, and generations to come. If the Katikiro talks about the mandate he's given by Sabasajja Kabaka, it is typified by a mace, which we call Damula. That mace has to be taken from a particular forest on the Sese Islands in Kalangala district. If that forest ceases to exist, the mandate which is given by the Kabaka to the Katikiro is under threat, the symbol of that mandate. So natural resources, the swamps, the forests, the lakes, the rivers, are all a fundamental part of what the kingdom stands for. Our totems for each clan has a totem and a sub-totem. Omuziro na kabiro. So it might be an animal, it might be a plant. It's generally the totem and the sub-totem, something that comes out of natural resources. Many of our totems have disappeared or are disappearing. The function of the clan system was partly, and I'd recommend to the Commission, a book of artistic drawings and actually a write-up by a gentleman called Ttaka on each of the clans. There's the Buganda Kingdom version, shows the totem, the sub-totem, and the value that the clan system had in maintaining and preserving these natural resources. We share the Commission's concern that wetlands, rivers, waterways, lakes, hills are being destroyed at a very alarming rate and unsustainably, or are being unsustainably used. And perhaps one quick point about leases and the renewal thereof, insofar as it impacts on the law. I should have introduced myself. My name is David Mpanga, and I'm the Sava Orders of Attorney General. So the law docket is what I speak for. To the extent possible, renewal is done in accordance with the law. There are determined cases by the Supreme Court of Uganda on how lease renewals should be handled by public entities. We adhere to that even though we're not technically a public entity. So to the extent possible, there is always good faith negotiation. There is an understanding that the renewal shall be done, given, first right of renewal shall be given to the sitting tenant, the occupant. And insofar as perceptions are concerned, in assuring people on the value of a lease, the Katikiro himself has said his matrimonial home rests on land that's held on leasehold terms with the church. My matrimonial home rests on leasehold land held by Kampala District Land Board. His matrimonial home, the Deputy Katikiro, rests on a lease held with Buganda Land Board. That's a lease issued by the Kabaka. So we believe in the value of leases, and I think everybody should rest assured that leasehold tenure is a valuable and more secure, in fact, form of lease of land tenure than the Chiranja holding.
Right, thank you. And now we will move to Commissioner Weshiwa-Sewunya.
Thank you, my Lord, for this opportunity. First of all, I'd like to add my voice to yours to thank the Katikiro and his delegation for having to find time to come and interact with this commission. I think it's a great opportunity for us, and indeed a great achievement as far as we are concerned, because we have received, my Lord, as you are aware, so many delegations from Bunyoro, Busoga, Mbale, Chigezi, Western Nile, from the cultural institutions. And Uganda was the only one which was missing. So we are very proud that you have admitted, you have accepted our invitation, and you are here. First of all, I would like to take you back, to what was mentioned by the Assistant Lead Counsel about some false information that have created a lift. It may be artificial, between the Commission and its chair and Buganda government, and indeed Ssaabasajja Kabaka. Last Sunday, there was a photograph of our chairperson and Ssaabasajja Kabaka under the New Vision grape vine. And the message there said, chairperson of the commission tells Kabaka to do away, not to interfere with the commission's work. When I read it on Sunday, I was shocked, devastated. I was here on Friday, and there was no statement to that effect. There was no statement at all to that effect. Why am I bringing this? Is that this commission, in its mandate, we've tried as much as possible to bring about linkages between the kingdoms, and also to find out what are the problems, what are the challenges with regard to land and our mandate. And this we have done very successfully. So we were a bit concerned when we read an article suggesting that the chairperson had directed the Kabaka to keep away from our work. That was not the case. It never happened. We were here on Friday, and in her closing remarks, nothing of that sort was made. So we want you to please accept that this never happened, and the relationship between this commission and you and your government and Kabaka's government is cordial, and we shall continue to cooperate. Maybe also, let me say this, my lord, this commission have tried as much as possible to safeguard Buganda Land Board land, to safeguard Kabaka's land. The statement to that effect was because there were a Nava and a Sava. He appeared here yesterday, and we asked him whether he has got any connection with the Kabaka, whether he has got any connection with the royal family. He denied. But he was the one who was carrying out a survey on possibly Buganda Land Board land, which precipitated us to take an action to say, no, stop, because this case is under investigation. Those are the kind of situations we get, and that's how sometimes we react that way. That please don't continue to do anything, don't continue to survey the land, because that land may not be yours. That is what happened on Kisule's land. We took a decision, and we said, no, please don't. So that was the background to that incident. Your presentation is wonderful. very good, very informative, and we are grateful. And we are happy that as a commission, we shall be able to quote that we received a document from Buganda government, headed by the Katikkiro. That to us will enrich our final report. It would have been too bad when you have no document or official presentation from Buganda government, whose population is about 7 million, a quarter of Uganda's population. So we are extremely grateful that you've come. Now, there is something, my Lord and Mr. Prime and Katikkiro, we have received complaints from clan heads and from various members of different clans in Buganda. They have come to us, but we find that maybe it would be a good idea for your government to handle those cases. One is involving my own clan, Ngeye clan. We looked at the file, but I think it is important that the minister responsible for cultural affairs in Buganda government should monitor what is happening within the 52 clans, the disputes, so that are handled by them rather than coming this way. But we are open to receive any complaint. We feel that some of this should be handled by your minister. Now, you mentioned, Mr. Prime Minister, Mr. Katikkiro, you mentioned the challenges. Me, I'm a great supporter of federal. And I also support regional government as a precursor to the federal system we want. We need to start somewhere. And I think the credit, let me say this, the credit goes to you, Wekitiibwa Makubia, Wekitiibwa Katende, Wekitiibwa Katikkiro Semwogere. You came out with a good document for the regional government. But there were challenges, as you said. But challenges are there, created by man, and they can be sorted by man. That's the way I look at it. So, what is the challenge that is there that cannot be solved? If there are, as you said, the 5 challenges, that we can talk about, the government can talk about. But let the spirit and the motive of the regional government be implemented, rather than waiting for years and years and years. I don't know, if you had a regional government, I don't know what you would have done. I don't know how Buganda would be. I don't know how many things you would have done. You have proved that without a regional government, you've done something. How about if you had a regional government with the money and with the ability you have? Uganda would be so many miles away. And I'm encouraging you, to take a lead in this. You cannot fail, not with Makubia, not with Impanga, not with Omrangira here, and others. You can do a lot, and you cannot say we have failed because of the 5 reasons. No. I'm appealing to you. You can react to it. I'm appealing to you to see how best we can handle it. Another concern, we have traversed this country. We have interacted with local governments, various leaders in various places. With regard to land, the area land boards, the district land boards have created a lot of havoc. These are the people, members of those committees, land boards, are the people who are giving away wetland, give plots on wetland. They are the people who are giving away the forest reserves. So it's a big concern. I would like to see the Minister of Lands in Buganda government to help save the land we have as far as the forest reserves are concerned, as far as the wetlands are concerned. And by the way, in the regional government, there's a provision. I may not be so sure, but there is a provision that the regional governments would be responsible to manage the land development and other issues as far as the wetlands and the forest reserves are concerned. I don't know what Buganda government has done as far as that, but the land is going. Another issue which we discovered in Uvende. There are people who come and settle on Buganda land. And they say, they call themselves customary tenants. He has come here for a week. And because of the link between the between the area land boards, there's a linkage there. And the district land boards, they advise them, oh, why don't you apply for not leasehold, freehold. There are so many of those kind of people in Movende. And I reported, I came purposely to give you that information. I met Prince David and told him about that information. I don't know what you have done, but that is what is happening down there. So, in view of that, would you think the existence of the area land board, the existence of district land boards, having created problems for us, that we should continue with them? We would like to have your view on that. My Lord, I think that is all I have for my particular.
Thank you very much.
Yeah. Maybe another, I need more clarification on Chapa Mungaro. I may be a landlord, Mayo. Then there are people on my land, Mayo land, tenants. Would a tenant apply for Chapa Mungaro? How would the Mayo land owner know? Do you consult him? That there are applications from your tenants on the Mayo land. we want to give them Chapa Mungalo.